jumping to SB 1159.
Right, SB 1159 related to workers' compensation coverage of COVID-19 illnesses. This is another bill that follows on one of the governor's executive orders from the summer. Back on May 6th, the governor issued an executive order that for a period of about, I think it was 2 months, it was like May through July, employees who tested or were tested positive or were determined to have COVID-19 within a certain amount of time after having worked could presume or had a presumption that they obtained the illness at work. This codifies that executive order, but it goes further and provides continuing coverage, essentially effectively immediately until it's repealed on January 1, 2023. It differs slightly from the executive order. The executive order was a little simpler. This one is applicable where the employee tests positive during the defined term of an outbreak at the employee's specific place of employment. And we'll get into those terms so you can understand that. It applies to any employer with 5 or more employees and to any injury or illness date on or after July 6, 2020. And employees who meet this presumption can be awarded under the workers' compensation system hospital, surgical, and medical treatment. They can get disability indemnity, although they have to exhaust any COVID paid sick leave, and they can get death benefits. So what do we mean by the specific place of employment? This would be the building, store, or facility where the employee performs their work at the employer's direction. It does not include the employee's home. So employees who work from home aren't entitled to a presumption under this SB 1159. Now, employees can have multiple places of employment. For example, if an employee visits multiple different work sites. And then an outbreak is measured over a 14-day period at the specific place of employment. And if you have 100 or fewer employees at the place of employment, then you would have an outbreak if there are 4 employees who test positive in that 14-day period. If you have over 100 employees, then it's 4% of them test positive over that 14-day period. That constitutes an outbreak. And then finally, if the Public Health Department or OSHA orders the place closed due to a risk of infection for COVID-19, that's an independent qualifier for an outbreak. And quickly, tests under this new law are limited to the PCR test. They don't include the antibody test. So, yeah, thank you. So if the employee's COVID-19 illness or death is going to be presumed to arise out of or in the course of their employment if they tested positive within 14 days of performing labor at the place of employment. And again, the key limitation, unlike the executive order, the place of employment had to have an outbreak during that 14 days. Now, there's also, just like with the executive order, the presumption is rebuttable, and at least now the employers have more guidance on what constitutes information or evidence that can rebut that presumption. The employer can use evidence that the employer has put in safety measures to rebut the presumption, and or that the employee has non-occupational risks outside of the workplace that could contribute to the COVID-19. No bright line rule, and I'd still be kind of pessimistic that you're going to be able to rebut that presumption, but at least more guidance on what you can do. Now, critically, as with before, there's a very short window for the employer to contest the claim. I think it's 45 days after the claim is made if you want to try to contest the presumption. And if you miss that 45 days, then you can only use information that you obtain after the fact. So I think really critical for employers to take away today is that this SB 1159 has new reporting requirements. An employer must report a positive test to the workers' comp claim administrator by email or fax within 3 business days. And that report has to include the date of the positive test, which is the collection date, not the date that the test came back, the address where the employee worked, and then in the preceding 45 days, the highest number of employees that worked at that address. And then you don't have to provide, or you're not to provide identifiable information unless the employee is making a claim or asserts that the infection was work-related. And this duty arises if the employer knew or should have known of the positive test, and the employer faces a civil penalty of up to $10,000 for failing to report the positive test or for submitting false or misleading information. Now, this applies going forward, but critically also, it applies to positive tests that the employer knows about that occurred between July 6, 2020 and September 16, 2020. So this new law went into effect on September 17th, but it has retroactive reporting requirements. And so employers have until October 19th to report any positive tests that occurred in that period.
And I'm getting a lot of questions from clients about what they can do to prevent claims either from employees and from the public coming into their establishment. And as you mentioned, I think following those protocols and having that buttoned up is going to help a lot. It might not overcome this presumption, but it could help in defending against these types of claims or overcoming that presumption.
Yeah, you're going to want to be able to show what safety measures you put into place that would have reduced the risk of transmission of COVID-19.
Great.